albeit that the jurisdiction does seem to permit it. But if you were going to remit it following finding that an error of law suggests, then in those circumstances
with an existing right or an existing obligation. And I accepted that in opening. I accepted that is the strongest form of retrospectivity. Our case was and remains that the principal legislation coming into force, and the principle, as your lordship saw, is that the presumption's strength depends on the degree of unfairness, and the presumption may be rebutted if the content or not.
I thought he did eventually accept what you're now saying.
Very well. Well,
that it was a spectrum.
That's where he started. To tab 26. The principle is at page 525, letter E. In the part of the requisites for the action of the statute is drawn from time antecedent to its passing, and just under D still says these cases demonstrate that when my friend placed reliance on the decision of the appellate committee in Wilson, that can be found at tab 33 of volume 2. 3.1. The answer to the difficulty lies in the principle underlying the presumption against retrospective operation, and the similar, but rather narrow presumption against interference with vested interests. These are established presumptions, but they are vague and imprecise. As Lord Mustill pointed out, the subject matter of statutes is so varied that these generalised maxims are not a reliable guide. As always, therefore, the underlying rationale must be sought, and this was identified by Lord Stork. Your lordships are familiar with that passage. Over the page, thus, the appropriate approach is to identify the intention of Parliament in respect of the relevant statutory provision in a very similar effect. Lord Hope does not mention Lord Mustill's principle, but at paragraph 98, your lordship, the mere fact, because it is no part of my case, that the mere fact that a statute depends for its application in the future on events that have happened. Citation from L'Office Jurifien and 882 letter B, Lord Roger identifies the principles occurred prior to the legislation coming into force would be unfair, and our submission was, and it remains, and I will seek to answer my friend's points, it is plainly and managed conduct or wrongdoing, or indeed any element of criticism of those acts. And our case was, and it remains, that the unfairness is under a real disadvantage in not having been able to seek clearance and take action in the light of the response. And my friend was reluctant, or certainty, required the creation by statute of a prior opportunity to seek clearance and to act accordingly. It would be very surprising indeed had Parliament intended that these powers could be used to base an FSD on transactions already completed, where the damage to business certainty is far greater than in relation to matters after the Act comes into force, because of the absolute reasonableness criterion. But when we come to the reasonableness criterion, he seeks to defend, say, his minimal assessment that the tribunal gives to the retrospectivity element. And if my friend is really going to say that the protection of fairness and the answer to the clearance point is the power and duty of the tribunal to assess reasonableness, then it is incumbent upon the tribunal to give real force, substantial force, to the unfairness that retrospective application causes. But Mr. Green will come to that. I'm dealing only with the provision was a necessary protection, notwithstanding the limitation on an FSD that it can only be available where reasonable. So the reasonableness criterion is no answer to the reliance we place on the clearance provisions as indicating the intentions of Parliament as to the scope of the jurisdiction. Whether to enter into the transaction, didn't know about it. It had no ability to seek clearance, and the jurisdiction is one based, rely on the reasonableness test, avoids the issue of principle which we're raising. The issue of principle is that it is inherently unfair to impose a substantial liability in the circumstances have identified. Then my friend contended that if you look at the contents of the Act and you consider the purposes of the Act, if your Lordships look at those matters, they show that Parliament did intend, with retrospective effect, that is by reference to events or transactions which occurred prior to the 6th of April 2005. None of the provisions are rendered redundant based on transactions or events. But again, with great respect, that avoids the issue because there is no dispute in this case that in order to justify that but for the acts and the transactions which occurred prior to the 6th of April 2005, the regulator has no basis for seeking. Page 202 of the bundle, of the core bundle. 194 in the middle of the paragraph. Present purposes, says the tribunal, it is enough to say that the regulator accepts that all the relevant events which it took into account in deciding whether it was reasonable to issue an FSD occurred in the period between 1999 and 2003, well before section 43. There are two provisions, section 38 and section 52. There are two provisions in the Act which expressly address retroactivity. And they do. Section 38 and section 52 is because Parliament's intention was to allow date when the relevant clauses of the bill were added. And the reason why Parliament thought it was right to allow for a degree of retrospectivity is because those provisions, section 38 and 52, are based on culpability. They are circumstances in which fault or misconduct can be proved, and therefore Parliament thought it right, contrary to normal principles, to allow for a degree of retrospectivity. Section 43, by contrast, as my friend has repeatedly emphasised, is not based on fault, it's not based on misconduct, and therefore Parliament took the view that it was not appropriate even to allow the limited degree of retrospectivity which is found for sections 38 and 52. And we say that Parliament did not address retrospectivity, it did not refer to retrospectivity in section 43, not because it intended to allow for full retrospectivity, but because it intended to allow for no retrospectivity, for very good reason. No fault, no misconduct that needs to be proved. Then there's to my friend yesterday, and your lordship asked my friend whether the regulator can issue an FSD in reliance on the events described in section 38(5)(a), that's the events that can prompt the contribution notice, even though those events preceded the 27th of April 2004, that's the date in section 38(5)(1). And my friend's answer was yes, the regulator can issue an FSD in reliance on such events. And this leads to a very odd conclusion, which cannot have been, in our submission, Parliament's intention. And it leads to an odd conclusion because the consequence of non-compliance with an FSD, as your lordships know, under section 47, is that the regulator may impose a contribution notice under section 47, a contribution notice that has the same characteristics as the section 38 contribution notice. And so we are in the very strange position on the regulator's case that because he says section 43 allows for full retrospective application, it is open to the regulator to obtain a contribution notice in relation to pre-2004 events indirectly through section 43 FSDs when Parliament has expressly prohibited the deployment of a contribution notice in relation to such historic events directly. And with great respect to my friend, this makes no sense whatsoever. It is another indication, we say a powerful indication, that Parliament cannot have intended to allow section 43 to be applied retrospectively in general terms, not back only to the April date of 2004, by contrast with section 38, which has limited retrospectivity, even though section 38 requires fault and section 43 does not. On the argument that Parliament intended to protect the interests of the pensioners, and indeed the interests of those paying a levy to the PPF. He says, look at that statutory purpose. That provides the answer. I accept, I did it openly, but I accept, I made clear, of course, that this is an important statutory objective. It's not the only objective of section 43. Section 43, as your lordships have seen, was also concerned to address, to deter moral hazard, but it is an important objective of section 43. But the potential FSD liability in section 43 is limited by the reasonableness test in 43(7). It's limited by the clearance provisions in section 46, and it's limited by the regulator's obligation under section 100 to consider the interests of all directly affected persons. So Parliament did not say that so important is it to protect funding for pension schemes in deficit that this takes priority over all other concerns. Also expressly excludes from PPF protection a pension scheme which went into winding up before that relevant date, 6th of April 2005. And my submission is the statutory purpose cannot bear the weight which Mr. Stallworthy seeks to place on it of demonstrating a parliamentary intention to apply section 43 in section 46 of the need for an effective clearance scheme which couldn't apply that there should only be limited retrospectivity even where the jurisdiction